That was in user error. I don't know when you said that. I had to double check multiple times which one was first. Yeah. Get it in my head. Which one was first.
Good afternoon and welcome to the call of the Tennessee Court of Criminal Appeals here in Jackson, Tennessee. Afternoon session. We thank you for being here. I apologize. I think we came in about a minute or two late. We have a issue with our clocks being a little bit off in one room than the next. We pride ourselves on being promptly and on time. I beg your forgiveness. Each side has 20 minutes per side. If the appellant wishes to reserve any rebuttal time, please do so upon introducing yourself. We are under the new protocols. We allow you to sit or stand, your preference, not ours. You may leave your mask on or you may remove it when you're talking, depending upon your preference, not ours. The panel today, to my left and your right, is Judge Ross Dyer from Shelby County. To my right, and my right hand person today, as always, to your left, would be Judge Camille McMullen from Shelby County. I'm John Everett Williams from right up the road in Carroll County, Tennessee. Have anything? Good. Let's call the first case.
Good afternoon, Your Honors. May it please the court. My name is Brennan Wingirter. I'm with the Appellate Division of the Public Defenders Conference, and I'm here today on behalf of the appellant, Ms. Johntel Billings. I'd like to reserve 4 minutes for rebuttal, Your Honor.
Yes, ma'am.
Thank you. Today, we're asking this court to reverse the judgment of the trial court for 2 reasons. First, there's legally insufficient evidence on the offense of aggravated assault. And second, the trial court erred in imposing a sentence of 4 years to be served entirely in confinement. I know that the court has read the briefs and is probably familiar with at least part of the record, but for the benefit of anyone who may be watching or listening, I'd like to give a brief statement of the facts to provide some context for those legal arguments.
Thank you very much.
Thank you, Your Honor. This case involves an ongoing dispute between 2 couples. On one hand, we have Ms. Billings and her boyfriend or fiance at the time, Mr. Scotty Rowe. On the other hand, we have Mr. and Mrs. Patel. The Patels were the housekeeping manager and night shift manager of an executive inn and suites motel. That's where Ms. Billings and Mr. Rowe were living off and on for about a year before this incident. So they all knew each other. On the night in question, Ms. Billings and Mr. Rowe were hanging out outside at the motel, and the Patels came outside to tell them to quiet down and go back to their rooms. A physical fight broke out after that. That fight was captured on the motel's security camera. That footage was played for the jury and is a part of the record for the court to review. On the video, it shows Mr. Rowe striking Mr. Patel and demanding that he give him money or his wallet. The video also shows Ms. Billings yelling at Mrs. Patel, pushing her backwards and then kicking Mr. Patel. Obviously, those facts are undisputed. They're on the video. After the fight, Mr. Rowe and Ms. Billings both were charged as co-defendants. They were charged with the aggravated assault of Mr. Patel, the simple assault of Mrs. Patel, vandalism, and attempted aggravated robbery. The attempted robbery charge was related to Mr. Rowe's demanding money. The vandalism charge was related to Ms. Billings throwing Mrs. Patel's cell phone. Mr. Rowe pled guilty to all 4 of those charges, and he was sentenced to an effective sentence of 3 years to be served in prison. He is not a party to this appeal. I just want to be clear for the record. I represent Ms. Billings, who's the only appellant here. Ms. Billings exercised her right to a jury trial. She was found guilty on 3 of the charges: aggravated assault as to Mr. Patel, simple assault as to Mrs. Patel, and vandalism. She was found not guilty on the attempted aggravated robbery charge. Ms. Billings was later sentenced to 4 years to be served entirely in prison. But before I talk about her sentence, I want to talk about the first issue, which is the insufficiency of the evidence on the aggravated assault charge. That was charged as to Mr. Patel. We are asking this court to reduce that conviction to simple assault because that is all that the proof that the state presented supports. The key difference between aggravated assault and simple assault, at least as charged in this case, is whether there was a bodily injury, which is required for simple assault, or whether there was a serious bodily injury, which is what is required for the aggravated assault conviction. Here, there was insufficient proof that the injury suffered by Mr. Patel rose from a bodily injury to a serious bodily
Well,
injury.
he testified, he had a broken wrist, he had surgery, and he had to have pins put in his wrist.
That's correct, Your Honor.
That's not sufficient for serious bodily injury?
It's not, Your Honor, because the definition, the statutory definition of serious bodily injury includes a broken bone only if the victim is a child. Mr. Patel clearly is not a child.
Well, it doesn't mean that, yes, the statute does say that, but the statute doesn't say no other broken bone can amount to aggravated assault.
That's correct. And we're not arguing that that's the case, Your Honor.
So he's testifying, they broke my wrist, I had to have surgery on my wrist, I had to put pins in it, and then I have to wear a brace in order to, because it's still weak and I can't work because of it. I mean, what is, in your brief, you talk about his testimony being confusing and contradictory. I don't see where, the one, that doesn't amount to aggravated assault, and two, how that's confusing. I mean, he may not speak the best Queen's English. It may be broken, but you know, it's one of those things where your client finds your victim, your clients accept the victim as they find them, and he may not speak great English, but at least it's pretty clear to me, even reading your brief, that that's a serious bodily injury. Why am I wrong?
I want to clarify 2 points on that, Your Honor. One is that what was confusing about his testimony was related more to the injury to his leg, and whether he could walk after the fight. That was the confusing part. He testified there was an injury to his leg that was bent, and they could not walk for several months. We know that that is not true.
Okay, so throw that out.
Okay.
Why is the wrist not sufficient?
So for,
I'm sorry, I just want to stop you on that point. You're distinguishing between the leg injury and the arm injury as the grounds for the aggravated assault.
that's correct, Your Honor.
And does it matter in this case?
It matters in the sense that the only theory that the state has proceeded under is that the wrist injury was a protracted loss or substantial impairment to that body part. That is the definition of serious bodily injury that they've proceeded under at trial and on appeal. So we're not talking about the leg at all. We're only talking about that wrist. And so as to whether the wrist injury is mere bodily injury or serious bodily injury, those key phrases, protracted loss and substantial impairment, are what the court has to look at. And here, Mr. Patel testified only to what a typical broken bone would involve. It was broken. He says he had surgery, there were some needles, and he was wearing a brace. But the state didn't put on any proof that that brace was even medically required at the time of trial.
Does the statute require expert medical proof?
It does not require it, Your Honor, but in the cases that discuss the difference between bodily injury and serious bodily injury, this court has said that if the state is going to try to elevate a simple assault to an aggravated assault, it has to put on more proof. So as I mentioned earlier, we're not arguing that no broken bone for an adult could ever be a serious bodily injury. We're just arguing that the state did not put on enough proof in this case. And that's not Mr. Patel's fault. The insufficiency of his testimony is not his fault. The DA did not put on enough proof to support that this wrist injury went to a serious bodily injury. For example, there were no medical records. No, those aren't statutorily required, but they certainly would help in a case like this. We don't have them. We don't know how long Mr. Patel was in the hospital, if he went to the hospital at all, or spent any
The
extended
clear
period of
implication
time.
is he went to the hospital for some period of time because he had surgery.
And he also testified that he was unable to work for 6 months.
That's the other part I wanted to clarify, Your Honor. So I'll go ahead and get to that. He testified that he could not work for several months. However, he and his wife were both still employed at their managerial jobs at the motel at the time of trial. He testified that he was able to make his nightly rounds as the night shift manager. He testified that he was able to sit in the office, which is what he normally did. The only thing that he testified that he could not do was what he called the heavy work. There's no explanation in the record about what that was.
So let me ask you this then. I'm assuming, I have not read his testimony, the transcript of it. I'm assuming this was all, he was asked about these kinds of things and what does this mean on direct and cross-examination. Was
To
that-
some extent, yes, Your Honor. It's actually his testimony is very short.
Okay. Why isn't this at the end of the day a jury question? If he's testifying, I can't do the heavy work, whether trial counsel or the DA asked him to define heavy work or not, he said heavy work, so there's something that's in front of the jury. He's talking about surgery, he's talking about pins, he's talking about a brace. Why is this not at the end of the day just a jury question? That they heard the testimony and sounds like a serious bodily injury to them.
The question of whether the injury is a bodily injury or a serious bodily injury is a question of fact for the jury. That's true. We're not disputing that. But the problem is we all know that juries sometimes get it wrong. And that's why this court reviews the legal sufficiency of the evidence. As a matter of law, what we have here, what the state put on as proof here, is not sufficient to take what would ordinarily be a bodily injury for simple assault, a broken bone of an adult, and elevate it to the Class C felony of aggravated assault by fitting that broken bone under the different type of serious bodily injury, which is the protracted loss or substantial impairment. We agree that that's an imprecise standard, and this court has said that it is imprecise. Because it is imprecise, this court asks the state to put on more proof. For example, other than not having the medical records, Your Honor mentioned there's a clear implication that he went to the doctor. It's an implication that he had the surgery. We don't know what kind of doctor he saw. We don't know whether he was receiving any kind of ongoing medical treatment after the surgery, other than the prosecutor pointing out that he was wearing a brace, which again, we don't know whether that was still medically required or not. Other than that, we don't know whether he was still seeing a doctor, whether Mr. Patel was undergoing any kind of physical therapy, or whether there were any lasting effects of this wrist injury that were going to prohibit him in his daily
So
activities.
that goes back to what the state has to put on as far as medical proof. If the victim is saying, I got beat up, they broke my wrist, and to this day, 6 months later, a year later, or whatever, it still hurts to the fact that it only feels good when I wear a brace. Does he have to have a prescription, so to speak, for that brace, or is his testimony not good enough to be a protracted injury?
The statute does not require him to have a prescription for that. But our argument again is that when we're talking about a broken bone of an adult, which by definition is not in itself a serious bodily injury, there has to be more proof than what the state put on here.
Well, but again, I get your argument, but what I'm having trouble with is if it doesn't require medical proof, expert proof, why is the victim whose testimony that it still hurts today, and the only way it feels good or I can use it is if I wear a brace? Why is that not sufficient?
Because it is the state's burden to prove that this was not just a misdemeanor simple assault, that it was elevated to a Class C felony aggravated assault.
But if it's hurting him a year later, why is that not protracted? And why is his testimony not enough to show or to meet that standard of protracted injury?
The definition is protracted loss or substantial impairment, not continued pain. And I don't mean to diminish at any degree what Mr. Patel and his wife suffered. And again, we're not asking for a complete acquittal. We're just asking for a reduction from aggravated to simple here, Your Honor. And as far as whether he was still in pain, again, we don't know that because the state did not ask him and that proof was not put on, which again is the state's burden. One other aspect to note on that is that Mr. and Mrs. Patel did not return the victim impact statement for the pre-sentence report. They did not request any kind of restitution.
You're not
So-
saying that has some bearing on the quantity of proof.
No, Your Honor, I'm just saying that it points out that even in sentencing, as far as the pre-sentence report, we still don't have evidence of any medical bills because that could have been where the restitution came in. So it was not put as part of the sentencing proof either.
I'm more interested in your sentencing argument. If you could speak to that.
Yes, Your Honor, of course. On the sentencing issue, of course, if this court agrees that the aggravated assault should be reduced, Ms. Billings receives relief there. But if this court affirms the aggravated assault conviction, we're asking the court to also review the trial court's imposition of a fully incarcerative 4-year sentence for a 19-year-old new mother. The state has claimed that the trial court's denial of any alternative sentence, and we're talking no probation, not even split confinement, the state is claiming that that is supported by several sentencing factors. And I believe this court will see when it reviews the record that neither the state's argument nor the trial court's findings are supported by the record. The trial court's primary reason for denying alternative sentencing was that Ms. Billings did not telephone the person who was compiling her pre-sentence report. That was going on in about 45 days, a month and a half between the time of her trial and the time of her sentencing. 11 days after trial, she gave birth to her first child. She was 19 years old. She admitted that she knew she was supposed to communicate with the pre-sentence report officer. She admitted she did not do that. The trial court faulted Ms. Billings for making, quote, excuse after excuse after excuse. And our position on the sentencing is that we're not asking the court to excuse her behavior, but the trial court ignored the fact that she was 19 years old.
What were the grounds for confinement?
The grounds for confinement, the state will argue that it was deterrence and the circumstances of the offense.
And is that supported by the record?
No, Your Honor. The trial court mentioned the word deterrence after it had already denied alternative sentencing. So there's no way it was a basis for the court's decision. For the circumstances of the offense, it is true that the trial court said that the video shows this was a horrible, vicious attack.
I want to speak to that. I tried to watch the video, and apparently it is corroded. Are you aware of the? Okay.
No, we were able to watch it.
Okay.
But we can certainly take care of that for the record. We'll fix that.
Okay.
So as far as the
Were the circumstances of the offense enough to support confinement?
no, and it's important that because deterrence was not actually a part of the trial court's decision, all we have as a possible basis were the circumstances of the offense. That is why we've argued that the court needed to apply the heightened standard of review, that the circumstances have to be particularly egregious or so offensive. And I want to point out that the offense of aggravated assault is already more elevated, more serious than simple assault. And even within aggravated assault, there are varying degrees of seriousness. The type of aggravated assault that is Ms. Billings' conviction is an aggravated assault with an allegation of serious bodily injury. That's a C felony. There are other aggravated assaults that are D felonies. They involve the reckless display of a weapon or reckless rather than intentional conduct. So the seriousness of this offense is already accounted for in the statute itself. And so when the trial court denies alternative sentencing based on the only possible thing, because you can't look at deterrence, being the seriousness of the offense, that is not supported either. Even when the court views this video, any aggravated assault involving a physical attack is uncomfortable, it is violent. But there is nothing about this particular offense as it was committed by Ms. Billings and Mr. Rowe that takes it beyond any other intentional aggravated assault with an allegation of serious bodily injury.
Well, who's in the best interest to say that, the trial judge or us?
Because there is a video here, Your Honors, the court can review that as well. The trial court seemed particularly bothered by the circumstances of the offense, but did not go into that heightened analysis. And again, the record shows the trial court was much more focused on Ms. Billings not calling the pre-sentence report officer. That was really what the trial court was upset about.
It wasn't so much, as I read the briefs, that she didn't call. It was that she had the ability to call and chose not to. She was doing other things. And these are good things. She was trying to make sure she had childcare for her kid, and she was doing things like that. But she didn't make a simple phone call to either her attorney or to pretrial or trial services to say, hey, can I set up a meeting? And she talked about how her phone was off, but she had 2 or 3 relatives at least who had phones. She was living with a relative who had a phone. So that's how I read from both briefs, the trial court's being bothered by her excuse after excuse. It wasn't just so much that what you didn't call and therefore I'm denying probation. It was, as I read it, you had opportunities and you intentionally chose not to do so.
And I want you to speak to this because I just want to piggyback on Judge Dyer's point. I want to be clear about this. The facts, she was pregnant at trial, and in the interim of following her conviction, she gave birth.
That's correct. She was 9 months pregnant at the time of trial.
Okay, and the trial court considered that excuse after excuse?
Exactly.
I just wanted to be clear on those facts.
And in addition to her being a new mother during those 45 days, again, she was 19 years old. She had virtually no criminal record whatsoever. She had 2 driving infractions and a public intox offense from when she was younger. None of those had required her before to complete a pre-sentence report or to undergo supervised probation. So she didn't have any experience. I'm not trying to excuse her behavior, not asking the court to, but as someone who has given birth to their first child in that month and a half and is doing everything they can to get back to work, to provide for their child, to get off of maternity leave, and not have to rely on her mother and her sister and her aunt, who are now raising her son, who just turned a year old a couple of weeks ago. Those people could have helped her do well and succeed on probation, but the trial court did not even give her the chance. And that is why we are asking this court not only to reduce the aggravated assault conviction.
What proof did she put on? I know it's in the briefs, but I think it is. At the hearing about her plans, should she have been given probation? You kind of just alluded to them about her family, but go, could you talk about that just for
I
a
will
second?
as best I can. Because there wasn't her portion of the pre-sentence report done, we don't have any specifics on what her employment was, but she testified that she had been working before the sentencing hearing, that she had delivered her baby. She was trying to get him into daycare. She was trying to get off of maternity leave so that she could go back to work. I don't believe it's in the record as to what her job was, but she was working. She did have a phone, but she could not afford to turn it back on. And she did have her family members who were going to support her, that were going to allow her to live with them as well.
Did those family members testify at the sentencing hearing?
No, Your Honor. They were there. There's an implication from the trial court's comments that they were there in the audience, but they did not testify.
Like recognized by the trial court, I see your mom,
Correct.
your grandmother here.
Exactly. Yes, Your Honor.
Was there any consideration or request for shock incarceration at all?
I don't recall that there was a specific request for the shock probation, but of course they did ask for alternative sentencing. And we discussed that in the brief, that split confinement probably would have achieved exactly what the trial court was going for in this situation, and it just was not even considered.
So if we agree with you, what do you think we should do with the sentence?
Assuming that the aggravated assault conviction stands.
Yeah.
Our position is that Ms. Billings should be given credit. She's now served about a year in jail. Under most sentencing decisions that I've seen, I'm familiar with at least, a year in prison is typical, and then the remainder is served on probation. She's now served that year. This court could order that she be released with instructions to serve the balance of her 4-year sentence on supervised probation. And of course, if she violates and does not take that opportunity, then there will be consequences. But we're just asking that she receive the chance on that supervised probation that she should have had to begin with. Thank you, Your Honors.
Thank you. General?
May it please the court, Catherine Decker for the state of Tennessee. Concerning the sufficiency of the evidence, there is certainly sufficient evidence to show that the assault on Mr. Patel caused protracted loss or substantial impairment to the use of his broken wrist. He suffered a broken wrist, and according to his testimony, which is the only evidence that we need. We don't need medical records, and that's clear on, I've cited some cases in my brief. There is no need for medical records. His testimony alone is sufficient to sustain her conviction. According to his testimony, he had surgery on his wrist. They inserted some pins, to stabilize it. And then he was ordered for 3 months to wear a brace while the pins were still in. The pins were in for 3 months. So surely, even if you just look at that 3-month period, during that 3-month period where he had stabilizing pins in his wrist and had been ordered by the doctors to wear a brace, surely the jury was reasonably could have concluded that he had lost a substantial use of his wrist. In addition to that, according to his testimony, the doctors told him that for the 2 months after the needles were removed, he still had to wear the brace.
That's his, so kind of to defendant's point, that's his testimony, which was maybe difficult to understand, difficult to follow, however you want to look at it. What's wrong with just introducing the medical records as well? I mean, doesn't that put you where you need to be as opposed to where we are right now?
It's not necessary at this.
I recognize it's not necessary, but when you have a witness who, as I read the briefs, who speaks broken English, and is hard to understand or doesn't really fully explain his injuries, what's wrong with introducing the medical records to make sure the state gets to where the state needs to be?
There would have been nothing wrong with introducing the medical records at this point when we're looking at the sufficiency of the evidence. That does not undermine the jury's verdict. And if you, when
I guess,
you read,
could I just piggyback? And I hate to interrupt you. My issue here is I think the state continues to contribute to the imprecise nature of this body of law by not making a distinction between the offense of assault and aggravated assault. Yes, we understand that the jury returned a verdict of guilty on an aggravated assault in this case based on this victim's testimony, but you have to agree with me that this is very, very borderline thin testimony when it comes to substantiating a serious bodily injury. Would you agree with me there?
I would agree with that.
And would you agree with me that it would be so much better for the state in this body of law, to Judge Dyer's point, to have put on some medical proof rather than hurriedly sitting down after this victim said in his broken English, surgery. I got the sense that he said it not in complete sentences, but he said surgery and pins. And I got, based on your brief and the context, that all of these things that you're saying, which make up serious bodily injury. I guess my point is, instead of giving a tongue lashing every time we get an issue like this, it would behoove the state to enhance or make a distinction between assault and aggravated assault, so we don't have to continue to have this issue.
I understand your point. I will say, though, that there is really not confusion in the record about whether he had surgery. And I have not said in my brief that there's confusion in the record. If there's confusion about whether his leg hurt, that's one thing, but we're not going on.
I may have misspoken. There is confusion. I read the transcript just so I could understand what was the actual proof. And my understanding based on his testimony is that it was very broken up in terms of whether doctors actually performed surgery or whether you gathered that doctors performed surgery on his arm from the context of how he said it. He said surgery. He didn't say doctors. He went in and had a specific surgery. I don't want to get that too down in the weeds here, but he clearly, English is not his first language. Okay, I don't know if the state sensed that the jury was getting frustrated with this issue, but the state did not enhance this victim's testimony in any way on that issue. They sat down very quickly after he said maybe 3 words that indicated that he had pain in his arm. And the trial court said, let the record reflect that he is wearing a brace. That was with the aid of the court that the state did that. They were not basically building a case by adding or enhancing this victim's testimony.
Yeah.
Is all I'm trying to say.
I mean, that's exactly the point I'm trying to get as well, is You have a witness who is giving 1, 2, 3 word answers, and the state's trying to prove serious bodily injury. And you're getting broken pins, surgery, which I have no problem in the right context and with the right testimony saying that's serious bodily injury. What Judge McMullen and I are both saying is what's concerning to us is that it is a heightened standard. It is a heightened crime, and there is a vague standard. Both parties admit there's a vague standard. And by just using this witness in this case the way the state did, the state is continuing that process, or continuing that problem, when it would be so much easier to put your witness on, let him testify how he needs to testify. And I'm not saying you got to call the doctor or the surgeon or anybody. Just throw the medical records out there.
And I also got the sense that the trial court was a little, I don't want to say upset, but at the top of this case, the state said, we don't need an interpreter, judge. We can go forward. And we know you went forward with victims, witnesses who clearly did not speak English as their first language, which is problematic in and of itself. So I just got to say, the state made its own problems in this case.
I understand your points. At this point, when the standard of review for the sufficiency is to view all the evidence in the light most favorable to the state, what is very clear in the record is that the victim testified that he had surgery, that the pins were inserted, and that they were taken out 3 months later. And that he wore a brace for those 3 months. And so if the question to the jury was this protracted loss or substantial impairment? And then it was certainly within the realm of reasonableness for the jury to have determined that 3 month period of time with a complete inability to use a wrist is a protracted amount of time. And so we don't need medical records. His testimony alone is sufficient. This isn't a typical broken bone type. This is proof that for 3 months he could not use his wrist. Additional proof that for an additional 5 months, well, for additional 2 months, he had the brace on. So there's 5 months total. And then for 3 more months, he was substantially impaired. He was still wearing this brace, and he couldn't use his wrist in his job. The question isn't could he do his job, but the question is, could he use his wrist?
And I guess the only question, and I'm move off sufficiency, because I think as the state, your bigger problem is with the sentencing, but he couldn't do the heavy work. We have, just to kind of bring this point home, we have no idea what that means. None. Like, you didn't even put on his wife or somebody else from the hotel or whatever to explain what that meant. I mean, the heavy work could be lifting stuff and therefore its wrist has a problem, or the heavy work could be just the way he described his job on any given day. Whether it's pushing paper around a table or whether it's picking up and cleaning rooms. We don't know. We have no idea what that means.
That's certainly true. And so that is for the time for the 8 months out past the assault. That's one thing. But if even just the 3 months where he had the pins in.
But if we don't know what it means.
And just, I sometimes get frustrated. What is it going to take for the state to stop doing this? I mean, I understand what the standard of review for the sufficiency of the evidence is. I understand this went to a jury. I understand, I've been doing this a little while. What's it going to take for them to make a change, to learn from what we're saying? I mean, you get the distinction and honor to get our wrath, basically.
I understand I'm the conduit to the trial attorneys. I understand that role.
Great job.
I was gonna say, someone who's sat in that chair for 15 years, it's not you that we're upset with.
So what's it gonna take? What do we have to do to get them to understand that there is a difference between assault and aggravated assault?
And so, shall I turn to the question of
You
probation?
can, unless you want to take a stab at my question.
What, how do we convince, I think this is what you're asking. How do we convince the state that they have to, like everybody was saying, try these cases differently, try them better, so that we really can draw a line between assault and aggravated assault, between bodily injury and serious bodily injury?
It sounds like something that that possibly one of our speakers at the DA's conference could address.
Well, I think clearly our opinions oftentimes say there's overwhelming evidence of guilt. I think we are sometimes, to guide others in other cases, we are to set minimum standards too and say this is almost bare bones. Anything less than this won't work. I mean, there was such an opportunity to show scars, to show the hand, to show how he had to carry it, how many days were in the hospital, how many days did the surgery take. There were hundreds of questions that are just left unanswered. And it does a disservice to the victim to not ask those questions. And if the victim can't answer them, then I think you got to get somebody else in there that can.
And this might be an example of the bare bones. There has to be, something has to be the bare bone level. And I would submit that this rises to the level of sufficiency because it is not unclear from the victim's testimony that he had surgery, the pins were inserted, and those pins remained in place for 3 months. And his wrist was, he had no use of his wrist for those 3 months while his brace was on. And the jury was reasonable to conclude that that was a protracted loss.
Well, had he said that, that would have been nice. But he didn't say that because he wasn't asked that. Correct?
And at this, well, the jury, he said,
He was not asked, were you unable to use your wrist for any period of time?
no, but not directly. But the jury is, and at this point too, at this standard, we are to draw all reasonable inferences in favor of the state. And the jury certainly did that. And this court defers to their determination.
We go to sentencing, please.
Sentencing, yes. Just fundamentally need to make a correction to the defense attorney's description of this assault, where she said that her client yelled at Mrs. Patel and pushed her backwards and then kicked Mr. Patel. And I'm gonna correct that because it's very important. And if you see the video, you will know how very inaccurate that description is, and you will understand why the trial court viewed the circumstances of the offense to be weigh highly against probation. Because in this case, Mr. Patel came out of the hotel lobby door, and then we can't see what his first encounter with the defendant and the co-defendant. We can't see that on the video. Mrs. Patel comes out a little bit later to check on her husband. And then we have the co-defendant and the defendant come back into the frame. The co-defendant is attacking Mr. Patel and has him on the ground. So he's attacking Mr. Patel, while the defendant, with raw brutality, is punching Mrs. Patel in the head, repeatedly punching in the head, while she's trying to retreat back into the hotel lobby. Swearing, it is exactly what the trial court is very bothered by when he says it viciously attacked. It's just raw brutality. The defendant.
I'm going to stop you there.
Yes.
Just, and I don't mean to beat a dead horse, so to speak, but this victim, this situation, if I'm understanding the trial testimony correctly, there were interaction between these two couples, the victim and her husband were workers at a hotel that the defendant and her boyfriend lived at, correct?
Correct.
They had altercations before.
That much we don't know.
Well, she testified to that.
She testified to that, but
The defendant testified to that.
the defendant testified to that, but the victim,
I mean, the defendant testified that she got into an altercation with them. They hurled racial insults at her. They spit at her. She admitted that she did something wrong, very wrong, in response to being spit on and yelled at.
well, two responses to that. One is that that's her testimony. According to the victim, he just went out and said, please be quiet.
The victim was not asked about this by the state or the defense. So the testimony that we have is from the defendant on this issue.
My memory is that the victim said he asked her to be quiet and go back to their room. And also, it's not that both victims said this. Mrs. Patel had done nothing. She came out of the hotel lobby to check on her husband. So this vicious attack on Mrs. Patel was completely unprovoked completely. And so after
I'm not gonna get down into those weeds, but the trial court viewed the situation in isolation as being unprovoked in any way in sentencing.
Because I think the question is, maybe not at that moment of the attack, but at least at some point in time prior, whether it was an hour, 2 hours, 2 days before, there was some sort of interaction between the two. Is kind of the reading I got, that this wasn't their first time to come across paths and be upset with one another. This had happened. They had had disagreements before going back sometime.
you have that impression only from the defendant's testimony, but that's
okay,
not
but to
what
Judge McMullen's point, no one asked the victims, hey, have you ever had a problem with this person? Have y'all ever had any run-ins? That was never asked. So the only proof we have, yes, is the victim, which is uncontradicted, right?
I see about the past.
No, I'm talking about her trial testimony.
What I'm saying is the victim wasn't asked specifically about whether they had negative interactions in the past. But that night, he said that night, he simply went out and said, it's 4 a.m, could you go back to your room? And additionally, the defendant has never testified that she had any kind of run-ins with Mrs. Patel. Mrs. Patel it's Mr. Patel who's the hotel manager and would have had interactions with them. But this just raw brutality against Mrs. Patel, there's no context for that. But besides that, because this is an offense against him, so finally, she's able to, so Mrs. Patel is able to retreat back into the hotel lobby. And for just a little while, the defendant is out of the frame of the video. Just a little while. Mr. Patel is on the ground. He's been beaten up. He's on the ground. And he's trying to crawl back into the hotel lobby. And she comes back through the frame and she sees him crawling back. And she, just as hard as she can, kicks him in the head. And that is why the trial court viewed the circumstances of the offense as weighing against probation. In addition to that, the trial court, that is not the only factor that the trial court used. The trial court denied probation based on multiple factors. The trial court did deny probation on the basis of the deterrence. Whether, if you read his, his statement finally, it doesn't matter if that sentence comes afterwards. It's just still all in there. And I know that in the defense brief and the reply brief, she talks about the Hooper factors. But the Hooper factors are applicable only if deterrence is the sole factor used to deny probation. But that's not the case here. So you don't have to go through the Hooper factors. The trial court can just look and as it's done in this court's upheld determinations against probation, where the trial court looks and sees it's an intentional act and says, well, that is the kind of thing that's deterrable, and therefore this is a deterrable act. So the trial court used deterrence, circumstances of the offense. And as I said, if you look at that video, you will clearly understand why that weighs heavily against probation. Also, the trial court found that the defendant would not be amenable to correction because, yes.
Yeah, so I'm gonna go ahead and jump in because I know this is where Judge McMullen's gonna go, but you have a 19-year-old mother. And when I say mother, someone who between trial and sentencing gave birth to a child. And so, okay, so she didn't call probationary services and she made that mistake. Is that really enough to say you will not abide by probation? I mean, doesn't the trial court, so you're talking about circumstances of the offense and how, as far as the victim is concerned, doesn't the trial court need to look at the circumstances of the surrounding the defendant during those 30 days or whatever it is between conviction and sentencing and realize that, hey, her circumstances probably actually don't show that she won't be amenable to probation. She's got a crazy set of circumstances right now. Isn't that a more rational, more reasonable approach to her circumstances and determining whether or not probation is a good thing or a bad thing for her?
Well, two responses. The first is this is not the only factor that the trial court used.
Okay.
And so there's circumstances of the offense and deterrence. But more than that, the trial court is the question at this point is not what defense counsel would have done or I would have done or this court would have done. The question at this point is, does the evidence support the trial court's determination? And so I don't think anybody is arguing that she did call or that she was actually prohibited from calling because it's not as if her phone didn't work the whole time. On direct examination at sentencing, she said it didn't work the whole time.
You and I both know we have cases all the time. I mean, where there's a probation revocation and you'll read the record and there was 2 or 3 violations filed before the case ever gets to us. And the first 2 or 3 every time are, they didn't check in. They didn't check in. And almost every single time the trial judge goes, hey, you better check in or next time I'm going to revoke you. And the trial judge, and usually the defendant gives some excuse of, well, I was going to my appointment, my car broke down or this, that, and the other. And the trial judge says, okay, that makes sense. And keeps them on probation. Here, we're denying probation to a 19-year-old brand new mother.
With virtually
With
no
no
record.
with no record.
And
I know it's minimal traffic violations, but I'm concerned.
But she didn't make one phone call. And the trial court here acts like she'll never check in. We'll never see her. She'll abscond. She'll be gone. That seems unreasonable, does it not?
Well, the question is his determination supported by the record? And it certainly is supported by the record that she didn't call. It's not clear that she doesn't have a prior record. She has a couple of traffic violations.
No,
and
I'm talking about what's in the record.
Public index. Well, we don't know what her juvenile record is because
Well,
she didn't call in.
It's not in the record.
It's not in the record because she didn't report to the PSI writer.
It doesn't matter why it's not in the record. It's not.
It's not, but I'm not sure she'd get the benefit of that. But according to the record, and the trial court didn't deny probation on the basis of her record. But as he sets out in his ruling, it's that she had one thing to do. She knew that she was, what the consequences of not doing were. She had one thing to do, and she didn't do it. She had every opportunity to do it, and she didn't do it. And not only that, she didn't really tell the truth to the court in the sentencing hearing about that. She initially said—
But he didn't say lack of candor.
He didn't, but no, he didn't. But it's just if you look at the record on that question, she says she couldn't call because her phone didn't work on direct examination. She persisted in that until the court said, well, look, what if I got your phone records? And then she said, oh, well, actually it did work. It worked for some time. So It did work. It worked for some time after, she doesn't say for how long, eventually it got turned off. But not only did her phone work,
General, would you mind if I call time? Are you okay?
absolutely.
I mean, I'm going 7 minutes over for you on this because my colleagues ask a lot of questions, but I don't want to cut you off, but I really think you've made your point on that, but do you need any more time?
I do not. I'll just conclude by saying that, that the trial court's ruling is deemed presumptively reasonable, and the defense has not borne its burden of showing that it was not.
Okay. Do you feel like you've had enough time?
Yes, I do, Your Honor. Thank you.
Thank you. I didn't feel like you'd object to me stopping at this point. I thought you made your points very admirably. Yes, ma'am, you've got 4 minutes.
Thank you, Your Honor. I just want to make a couple of points. First of all, I did not in any way intend to misrepresent what the video shows. We are certainly I didn't realize the video was corroded or corrupted. We will fix that. We will supplement it. What the state calls raw brutality as to Mrs. Patel, on that point, I just want to say that Mrs. Patel, the conviction was simple assault, not aggravated assault. The arresting officer testified only that the Patels suffered facial abrasions and bruises. Everything else was the testimony from the Patels themselves, which the court will see from the record exactly what that did or did not prove. The second thing, Judge McMullen, you asked about a specific question about whether shock probation was requested. Assuming that the control find is working on my PDF, that's not in there, but the trial judge at the end, this is page 25 in the transcript of the sentencing hearing, the trial judge says, now I have to consider whether probation or some alternative sentencing is appropriate. So something other than probation was mentioned by the trial court himself. Judge Williams, you mentioned whether there was a complete denial of the loss of Mr. Patel's wrist. And I want to be clear that the implication that there was complete inability to use his wrist or that he could not use it at all for any period, whether it's the 3 months, the 6 months, the 8 months, those are the state's words. Those are not Mr. Patel's words. That's not in the record. Finally, I will say again, deterrence was not part of the trial court's decision. It was an afterthought. It was mentioned in passing after the court had already denied alternative sentencing.
But I mean, I get your point, but if I'm talking and I say, you know, I've looked at the circumstances of the offense and this is just a case where I can't grant probation. And in addition to that, and then I say something else, was that not all part of my thinking?
Here's the problem with that, Your Honor. The problem is that we've given trial courts a lot of discretion in sentencing. And the state even says in its brief that the trial court's decision included implicit findings and a common sense determination. Our position is that no matter what Byes did to the appellate standard of review, trial courts still have to put their findings on the record. They still have to consider the purposes and principles of sentencing, and they still have to make conscientious and intelligent judgments. And this is simply not one of them. We're asking this court to reverse the aggravated assault, reduce it to simple assault, at the very least, reduce Ms. Billings' sentence and release her with time served at this point. Thank you, Your Honors.
Thank you both. I guess our frustration sometimes comes to light when it seems like issues wouldn't be in front of us. It had a little better preparation been done below. That's the way it's always going to be. We don't mind hearing the cases. We enjoy it. It's just tough for you as it is for us. And thank you for presenting both sides very well today. We'll stand adjourned to the call of the next case.